Just saying hi to everyone who's here. Welcome.
Thank you all for joining. I hope you're all looking forward for this weekend. We are doing a kind of a topic that a lot of people wanted to learn, and especially the self-sponsor option that you had mentioned, and as well as the cap exempt H1B option concurrent. So I think probably it will be very interesting for the others to learn, Nicole.
For sure. Very excited to definitely talk about it and to really share some insights. Uh, I know that a lot of you are probably sitting here always wondering, like, what can I possibly do? I'm always stressed. I'm always worried because everything feels unstable. So hopefully by the end of today's presentation, you guys can feel like there is a plan B, there's a plan C, there's a plan D, E, F, and the whole alphabet soup that comes with it, both on the visa numbers and names and the number of plans that you have as your backup.
All right. I think we can get going, Nicole. We got
Sure.
sort of live audience, and then we also live on Facebook as well. All right. So
Perfect.
hello, everyone. So today we are hosting this sponsored webinar by Manifest Law. I have Nicole, who is a principal immigration. Am I right, Nicole? Principal immigration is the right title for you?
Yep, principal immigration attorney. That is
Principal
absolutely correct.
immigration attorney and experienced immigration attorney in terms of H1B employment, immigration employment visas. She is here to educate about what happens if you get laid off while you are on OPT or during STEM OPT or H1B. The webinar is going to be in two sections. First part is she's going to walk through the slides and the available options that are available for folks who got laid off during H1B or STEM OPT or during OPT times. Then we will do a Q&A. The Q&A is going to be done through the attendees entering your questions in the Q&A tab that you see on the Zoom. So you can go to the Q&A tab, you can type it in the questions, and then Nicole will be answering. All right. And disclaimer, this is an open public session, and we are talking about immigration related questions. So this is not an attorney client privilege kind of scenario, right, Nicole? Right way to tell?
Yeah.
Yep.
So very difficult to maintain confidentiality over chat.
Yep. Yeah, good way. Um, so the questions that you're asking, please try to keep it short. Don't describe a lengthy scenario. It's very hard for us. You can always request a consulting meeting with Manifest Law, and one of their attorneys will be able to help you out as well. Nicole, welcome to this webinar series. We're going to be doing a bunch of them in the next 3 months and beyond, and excited to have you here. Please give a quick intro about you and what you do for Manifest Law, and then we can get going after that.
Sure. So thank you so much, Raghu, for having me. Welcome everyone to today's webinar. So briefly, my name is Nicole Ganara, as Raghu mentioned, principal immigration attorney at Manifest Law. Manifest is a tech-enabled law firm. I think we're quite innovative. We're really trying to change the way that legal practice looks like, whether it's this year, next year, and the next few decades. We find that the legal practice is a bit antiquated. I think all of you here who've ever met a lawyer or worked with a lawyer can probably feel that the most. For many of you who are studying STEM, you probably are seeing us with physical folders, pen and paper. We're looking to change that game. Personally, I've had a lot of years of experience working in immigration, in business immigration in particular, but I would say that a lot of my areas of focus are in talent visas, the business immigration alphabet soup, the H, the E, the L, the O, and a lot of those employment related applications. But I'm also very well versed on individuals who are on student visas, which can be a little bit unique compared to a lot of other practitioners out there. And I'm also very fluent on the intricacies that the schools face in maintaining those programs, having advised those schools before in the past. But by the end of today's conversation, like I mentioned, I hope you get a lot of resources and tools in terms of really planning your journey here in the United States, how to deal with that sudden scenario of a layoff when you are on OPT, STEM OPT, and also your H1B and those pesky grace periods, so that you feel as comfortable as possible, because I can deeply understand how stressful of a scenario that is. So let's say you are working. right? Whether you're on the H1B, the OPT, and the STEM OPT, all of a sudden you are called into a room and you're told, hey, we're going to be doing layoffs. You are one person who is going to be laid off. So, what I want to first talk about is what are your immediate considerations after a layoff? Number one is that you need to understand how grace periods and the unemployment rules work when it comes to the statuses that you are in. If you are on an H1B, the moment that you are terminated, and usually in a layoff, you're given some level of notice and then you will be told what your last day is. But on your last day of working, you basically get a 60-day grace period on the H1B. Or, and this is where a lot of people fail to realize this, until your I-94 expiration, whichever is earlier. So, what does that mean? Let's say you were on your H1B and it was approved until September 30th of this year. Even if you were terminated on the 15th of September, it doesn't mean that you have until November as a 60-day grace period to stay in the United States or change status. You're only allowed to stay here up until that end date of your H1B I-94, which was, in my scenario, September 30th. And that is really important to remember. A lot of people have made this mistake because when they go on Google or you see those AI summaries, they immediately go into 60-day grace period. But this is the part that I want every single person on H1B status to remember. Another thing that I really want to emphasize is the question of what counts as a termination, right? Or when is my last day to calculate from? So many practitioners at times go, well, it's your last pay stub, right? Because whenever you file for maintenance of status applications to show that you've been maintaining your status, you usually show your last two pay stubs. However, if you go really deeply to the Department of Labor FAQs related to the labor condition applications associated with the H-1B, or really deep into some of the interpretations, the government has an interpretation where it's the last day that you're actually providing services to the company, right? It's not that if you're put on garden leave, which is this whole thing where if you have a non-compete agreement and in your contract, you're allowed to be paid out for 6 months to do nothing because you have this non-compete, right? That you can just maintain your H1B the entire time. You're not working. You're just being paid out, right? So that had an interpretation that the government took negatively. So be mindful. It really should be calculated from the last day that you were providing services, that you were actively working as an employee for that organization. And a really good attorney will be able to help you demarcate that line. For those of you on OPT and STEM OPT, when you are laid off, remember that you have unemployment days that you're allowed to essentially have, right? So the rules differ from those who are on OPT and those who are on STEM OPT. For OPT, and if you're only entitled to OPT, you are provided up to 90 days of unemployment cumulatively. So that means that you tell your school that you've been terminated and when your last day is, and then you start accruing those unemployment time in order to find a new employer for your OPT. For STEM OPT, the cumulative total increases up to 150 days total, but it's across the time from OPT and STEM OPT. So it's not like if you were unemployed for 80 days on your OPT, that if you're on your STEM OPT, you get an additional 150 days. It's that if you were unemployed for 80 days on your OPT, that means you only have 70 days remaining on your STEM OPT. Okay? So that's a really, really important distinction. It does get messed up a lot. I've even seen DSOs make those mistakes. The reality, and in my experience, the more that you try to maintain your own records, the better, right? But you should also still keep in touch with your international students office, keeps those records that you did attempt to maintain compliance. Those help mitigate a lot of the maybe future issues that can present itself if you do fail that compliance in some form or way. So first steps, like I mentioned, track your days closely, line up options before limits expire, report employer updates in SEVIS. So if you're an OPT and STEM OPT, you got to tell your international students office that you are no longer employed by that organization, and you should be exploring your alternative options, especially when you're on your H-1B, for transferring, change of statuses, or new petitions. And we'll talk much more closely on what those options look like.
So, Nicole, I got a
So,
question
sure.
before
Mhm,
we go to the next one. So,
mhm,
one of the things that you mentioned is the day you stop giving the services is your last day of employment, and the 60-day
mhm,
grace period starts from there. So,
mhm.
how would USCIS know And have you seen scenarios where they have asked an RFE to send, here is the date, versus if they give a last 2 months of the pay stub, then it looks as if the person was employed for additional 60 days. Let's say they are supposed to get paid for another 2 months. So have you, so as per the law, the last day of services is your last day of employment. And let's say they get paid for extra another 60 days after that. So the
Right.
people assume that I got that 60 days of where I'm getting paid plus another 60 days of grace period, like 120 days. So that's not the case, right?
That is not necessarily the case. Here's what I'll say. In practice, it is true that some people get away with it. You're right, right? The pay stub makes it look like I'm still actively working. But what I'm really talking about now is the current administration and how you have seen them evolve and get, and almost somewhat begrudgingly, better and better and better at what I call data mining and figuring out like what these documents actually mean, right? So I'll give like an example. Nowadays, if you're working for big tech, right, or even like companies that are name brands, they announce these layoffs and sometimes they even announce the terms of these layoffs. Remember with Elon Musk when he purchased Twitter, changed it to X, and said that we're going to be terminating X number of employees? There was also clear indications in like, oh, we're going to let everybody who's laid off be paid out for an additional 3 months, etc. Right? So in that scenario, there were tons of individuals who were being laid off by Twitter because of this announcement, who relied on the 60-day grace period based on their last pay stub. But the government knew, or at least the officer knew because it was on the mainstream news, that it wasn't that your last day was on the pay stub because collectively everyone had agreed to take this 3 month pay period of doing nothing, right? So that's one way that they can find out. The second way is really they could always just call, the employer, or it's when the H1B got revoked, right? If the H1B, the previous one by your employer, was revoked because in normal practice you file to withdraw an approved H1B when you've been terminated, that could be a way for them to check the consistency between the pay stub and when the employer requested that withdrawal, right? And they're nowadays getting much better in checking for those consistencies compared to before when they were looking really just to the limitations of that particular application that's in front of them. Does that necessarily mean that every single time someone is doing this, that they're going to check to that depth? The answer is no. But I always take the most conservative position primarily because the downside is so significant. Even if it is a 2% chance, a 3% chance, something that seems very de minimis or minimal, right? The downside impact is, well, you are out of status now for an extended period of time. The government may feel like you may have omitted or misrepresented a way that you have been here in the United States. How does that impact the rest of your life here now in the US? So taking the path of conservatism in this case may be better just to ensure your stability in the future here.
Okay, all right. Sounds good. Okay, so you can go to the next slide.
Right? So alternative immigration pathways. So the reason why we call it alternative immigration pathways is many of you are probably very familiar with changing your status into B1, B2, F1, and the like, and we will talk about those ramps in a later slide. But I want to talk about first some of the categories that maybe you may not have heard of in the alphabet soup that makes up visas. And you actually hit the nail on the head, Raghu, in the beginning, which is self-sponsorship, right? Self-sponsorship is this big kind of term that's being kind of thrown around left and right ever since the modernization rules that came out last year towards the tail end of the Biden administration. So I'm here to kind of demystify aspects of that, but also talk about concurrent cap exempt H1Bs where some of you may not know about it. So let's talk first about self-sponsorship, though. Under the modernization rules, you can form your own US company and sponsor yourself if you already have your own H1B. Now, the reason why the government allows for that is they recognize that people are entrepreneurs. People need to build businesses. But what they didn't really explain until they started adjudicating the applications is what are they looking for? So it's one thing to set up an LLC, a C Corp, right? To have a brilliant idea and a concept. But it's another thing to prove to the government that you have enough of a business to maintain an H1B. A lot of people forget that H1Bs still require you to be an employee and to be paid for your time. So even if it's self-sponsorship, you need to be able to show to the government that for the amount of time that you're requesting, and quick note here, an H1B approved for self-sponsorship is limited to 18 months, not the full 3-year period, although you can keep extending it for that cumulative 6-year period that you're entitled to under that H-1B. But you need to show funding for that runway. So if you're telling the government, hey, I'm going to be paid 50K per year, they want to see what that looks like in the bank accounts belonging to the business. They usually want to see some level of a business plan, pitch deck, just things that are going for the business to make them feel like this is going to be a qualified, let's call it experience, that you can maintain and truly maintain your H-1B. So I honestly do treat this type of H-1B more like an investment visa, right? I have to be able to parse out to the government the trajectory of your business and why you're going to be able to maintain this particular status during that time. But with self-sponsorship, you need to have that entity. You should have a bank account. You should have something to show that the business, something is going for it, right? Whether it's through funding, activities, operations. And those are really some of the key hallmarks of what makes a great self-sponsorship case. Um, for those of you who are on OPT or STEM OPT and you're out of time, right? So what does that mean by out of time? I really can't, like, I didn't win the H-1B lottery. I don't have any unemployment time left. What can I do, right? You can skip the H-1B lottery. It is possible, right? But this is kind of a loophole that not a lot of practitioners talk about, but you should know about, which is that you can file something known as a concurrent H-1B for a private employer based on an approved part-time or full-time cap-exempt H-1B. So I said a lot of crazy words, but I'll explain it in an example. Imagine you had a 5-hour a week role at your university to be a graphic designer, right? The university sponsors you for a cap-exempt H-1B. And a cap-exempt H-1B is just an H-1B that doesn't require you to win the lottery, and it's because a university or a college has that provision. Nonprofit research organizations do too. So once that case is approved, imagine it's a hook. So the concurrent H-1B is that you file a second application that hooks onto that first hook that says, at the same time, I'm going to be working for JP Morgan 40 hours a week for them as a graphic designer as well. That's allowed. So long as you maintain that 5-hour a week role as a graphic designer at that university, you can maintain that concurrent employment for that private employer. That is something that does exist. Now, I understand that part-time role may be hard to find, but there are programs out there. Some universities are very much open to it. I recommend that you reach out to your DSO or really your professors. And usually the faculty chair or whoever's responsible for the department can figure out what roles, what research assistant roles can qualify for these cap-exempt H-1Bs. So you can try to find out how to get to that point.
So basically, they do not have to get into the lottery to say work for another cap-based employer. As long as they have
Yep.
an active CapEx and H1B approved, they can have a concurrent H1B for another employer who typically need a regular H1B through the quota.
That is correct, but it's not just an approved cap exempt H-1B. It's that you have to have an active part-time cap exempt H-1B. So what I mean by active is that you need to be working for that cap exempt employer throughout the whole period of time. You have to maintain it. The moment that you lose that role or you're not working on it, then the concurrent H-1B fails as well because that was the hook that got you that approval. Now, what I will say is that this is supposed to be like a bridge. It's a temporary bridge. No one is saying that you're going to be maintaining this cap exempt forever. You should be building into something else. You should be looking at alternative pathways or continuing to enroll in the regular H-1B until you win with your regular private employer. But we can talk about another pathway, which is really interesting for STEM individuals to get out of this vicious cycle of H-1B scenarios, right? Because the self-sponsorship is great, but the self-sponsorship requires you to already have an H-1B. The other one requires you to have a very specific thing, which is a university or a college or a nonprofit research organization. And it's the J1 research scholar and specialist provisions. Many of you have heard of the J1, but many of you may have heard of the J1 as an intern and trainee program. Some of you may have heard about it because of something known as 212E, which is the foreign residency requirement that says that you need to go home for at least 2 years after you graduate from that program or that J1 thing. But that doesn't necessarily apply to all countries. They actually severely reduced the number of countries that have to do the foreign residency requirement. But what I will say is, why am I talking about research scholars and specialists? I'm talking about research scholars and specialists because the research scholar J1 is 5 years, guys. And it's not just for universities. It's a 5-year work visa that can be applied for at any time for you to provide and conduct research or contribute to research, even for private employers. So I keep using JP Morgan, but I think it's because I bank at Chase, telling everybody that, right? But let's imagine that JP Morgan has a really, really cool project to redevelop digital banking infrastructures, right? We all know digital banking is innovation. Since it's an innovative technology, let's say they needed engineers to help research and produce that new technology. A J1 research scholar can do that. You don't need to sit in the lab. You just need to be contributing to something that's innovative and new, right? Something that requires you to conduct some level of research to contribute to that project's success. And you must demonstrate that you have expertise in that field. So if I'm an AI engineer and JPM needs an AI engineer, and I have a degree in computer science and some experience working in artificial intelligence, there is an argument to be made for the J1 Research Scholar Program. 5 years. And unlike the H1B, immediately spouses can work. They can apply for an EAD card through the J1 program. And another brilliant thing is that the J1 is agnostic on who pays for the fees, right? So this is something that you can propose to individuals. Now, it is still anchored to research. You still need to be able to prove that you are using elements of research to contribute to your private employer's work, but it can be done. The alternative is specialist. Specialist is more like you're doing something that is very specialized and you're sharing that knowledge to the employer. For example, if you have been an independent contractor or consultant or working with an IT company that's servicing a company and they want you to directly be brought in for implementation or training or sharing skills, the specialist J1 is allowed to be there. It's not as long as the research scholar one. Specialists are only for 1 year, but it's effectively renewable for 1 year periods at a time. You just have to exit the country and keep coming back for those new 1 year periods. But genuinely, guys, really consider the J1 Research Scholar Program. There's more that I can talk about it, but in the interest of time, like do some research. It's actually a really cool program.
So, Nicole, I got a question on
Hmm.
the self-sponsorship.
Yep.
Do we have to prove the employer-employee relationship with that 18-month H1B that will be approved through the self-sponsorship?
So far, the answer to that question for me has been no, not really. You still need to show that you are an employee. But that whole question of bona fide employer-employee, that whole section that used to be in place, that whole memorandum was revoked, right? So it's quite flexible. You have to show that are you able to be fired or were you hired? Does the company have control over your work? Or alternatively, does the company have the right to kind of determine your work? But again, when we do these self-sponsorship cases, the government understands that you own 100% of the company. And what they're really looking for is, okay, are you actually doing something that requires you to have a specialty occupation level of knowledge? So my answer to the question is that when it comes to the bona fide employer-employee relationship, it's not to that tight anymore as bona fide employer-employee relationship. It's can you even functionally be treated as an employee, quote unquote, and do you actually have the runway and income and operations to even call yourself as someone contributing work to that particular company? Because when I go back to that operations question of like that runway, it's not even just financial. It's literally, do you have enough work to do,
Mm.
right? Are you actually going to be using your knowledge? Just to give a quick example, Raghu. So if you're telling the government that you're going to be the CEO of the company, the government has to believe that most of your work is going to be using your specialized knowledge. But how can you show that if there's administrative things related to your company, right? Booking meetings, going to places, right? The government will say, well, does it actually need your specialized level of knowledge? So that's something to be mindful of when it comes to applying for this self-sponsorship. No one's saying you need to have a large company. You need to just have proof of systems in place.
Okay, all right. There is a question relevant to that. Should we review the question now or come back to it once we finish the presentation?
We can come back to it, I
Okay, sounds
think.
good. All right, so we can go to the next one.
Okay. Long-term options beyond the H1B and OPT and the like. So sometimes what I think to a lot of people, other than the immediate options and some of the cooler pathways, is what can you build up over a period of time as early as possible to give you more freedom, right? So that you don't feel as destabilized by the fact that the H1B is very sudden, very unilateral, right? You don't really have control over your own destiny at that point. Especially for OPT and sub OPT as well, where you feel like every day the news is like, oh, we're going to be changing how F1 students are going to be treated here in the United States. So what I tell people is you need to start thinking about the longer term pathways like the O1 and then the green card pathways like the EB2 NIW and the EB1A. So for the O1, the reason why I really like this visa is that there's ways to structure it where you have way more control and flexibility to stay in the United States by not relying on one employer. O1 visas are really primed to be fit for multiple employers through something known as agent petitions. An agent petition is where we designate a third party company or person, US citizen or US company, and they basically serve as a basket to USCIS, showing that you have multiple job opportunities here in the US, engagements that allow you to stay here. So let's say you have that full-time job using JP Morgan again, right? If JPM decides to have a full-time job with you, right? But you also have another gig for consulting another company out there. Even if JPM decides to terminate you, if you still have that side consulting gig and that was presented in your agent petition for the O1, you can still stay here despite being terminated by JPM. So there's that level of freedom. For the O1, this is a visa for professionals with distinguished achievements. Examples are awards, publications, high impact like critical lead roles, high remuneration where you're paid more than others. But when I'm saying that you can start early to build towards that category, you need to consider building the right evidence or getting corroborating evidence, right? So one of the categories that's very well known is something known as judging. You're judging the work of others. Guys, when you're in college or when you're in universities, your best resources are actually right around you, those scholars and those professors. By virtue of their profession, they have to do a lot of these peer review activities because they're scholars, they're academics. Talk to them, ask them, what databases did you get into when you graduated? What experience do I need to get in order to get into these databases that allow me to do peer review? Alternatively, being very active in your own communities and finding those opportunities like hackathons and the like can also be very helpful to build up that credibility. I know some of you may be thinking, well, some of the hackathons that I have access to in the beginning are very small. Maybe they're scholastic, maybe they're for children. But remember, you have to start somewhere. How do you establish your credibility as a judge? How do you leverage that you have that experience to get into the right places? Well, you got to start somewhere. You got to start small. So the earlier you start building up that ramp, the better. We have really great resources on Manifest's website in terms of like some of the things that I would consider for you guys. But quick other example is writing about your work. Articles are fantastic ways to kind of get yourself out there. But for the green card pathways, definitely much more long term. But to just touch upon it, EB10IW, you can self-petition saying that you are going to be doing work or you are doing work that benefits the United States national interests. For those of you who are born in India, I understand that it's a really, really long wait time, but the beauty of the EB2NIW is that it belongs to you, right? So that's one thing to bear in mind. For the EB1A, it's also a self-petition application. It's the big brother, let's call it, of the O1 visa with very similar requirements, not exactly the same, but similar. But that's also the reason why I do like the O1 is because you naturally build up towards an EB1A when you are building towards an O1. The EB1A is kind of like the pie in the sky, guys. If you build towards it a lot earlier and you show that credibility and sustained level of acclaim over a period of time, it's more likely to become yours at some point. But yeah, you want to start building a portfolio of evidence as early as possible to prepare for some of these applications.
All right, fantastic.
Okay. So I'm going to go into the FAQs because this is something that we talked about early on. I mentioned that the usual things that people talk about when they get laid off are H1B to H4 to H1B, H1B to B1, B2 to H1B, or OPT to B1, B2 to something else, or H1B to day one CPT. I'm going to touch upon all of these very quickly and in the detail that I think you need to know. So path number one is H1B to H4 to H1B. I see this a lot It's not a bad idea. It's not a bad idea. If you have a spouse who has their own primary H1B, changing to H4 is not a bad idea because you can file the F539. It's a very technical type of application in my point of view because you just have to really prove those check boxes, which is I've maintained my status. I'm married to someone who is a primary H1B holder. Therefore, I am entitled to this particular status. The tricky part is actually changing back to the H1B. Why? Let's say you file the H1B to H4. You filed it on September 1st. I think all of us know that the 539s to H4 are taking a really long time to process at the moment. 2 months in, or 3 months in, even, right? You get the job offer of your dreams. You finally go through the interview process, and they're like, okay, we're going to sponsor you for your H1B. But you're already outside of your 60-day grace period at that moment. And now you're on this pending H4 that hasn't been approved. So what do you do? So as a practitioner, when I advise employers who are dealing with this situation, the first question that I ask is, does this person have a valid H1B visa stamp still? Because if you do, then instead of filing to change your status from H4 to H1B, because the downside of filing that change of status back to H1B is the government will always come back to me and say, we need to adjudicate the H4 first because you're still in pending status. That's the issue, guys. So instead, I tell the employer, let's consular process this, right? Approve it as if it's not a change of status, pay premium processing, get it approved within 15 business days, and then have the person take that approval notice once we receive it, exit the country, and come right back. You don't have to get a new H1B visa stamp when you have a new employer, so long as your H1B stamp remains valid. That H1B stamp is not beholden to a specific employer, is the one thing that a lot of people forget. And when you exit and you come back, the officer at the border or at CBP passport office will basically adjust your I-94 on their records for that full period of time for that new approval. And now you're back on H1B status in the US. And that is way faster than layering a second application on top. Of course, I do check if that person, even if they filed the 539 to H4, if they're still in grace period. You never know. Sometimes you file really, really early. If they are still in grace period, then I would file the H1B change of status and ask the person to withdraw the H4 application because it's not really needed anymore. For path number two, oh,
Would it
sorry.
be,
Yeah.
would it be possible for H4 to H1 to do a premium processing? Is that an option? If 539 is pending, Nicole, and then the person gets a new job offer, they want to go back to H1, is premium processing an option for them to get them and then withdraw the pending 539?
Yes, it is possible to pay for premium processing for the H1B. The only thing is, again, this is a tactical filing, right? If I file the change of status from H4 to H1B and you are outside of your grace period at that time, and you're just here based on that pending H4 application, if I premium process the H1B, it can trigger an RFE because the RFE will say, you have a pending application. You don't really have a status to change from because you're on a pending status. We must adjudicate that H4 first,
Mm.
right? So sometimes strategy wise, it actually doesn't make sense for you to premium process your H1B in this scenario. I prefer my other scenario, which is leaving the country and coming back, because it's actually much faster. But I know the risk for those of you who don't have a valid visa stamp, then that's where things get very dicey and very tricky. Under the Biden administration, they tried to consolidate these things. If they see that you're going to premium process your H1B, they do pull that H4 file and they try to adjudicate it. That is not the case that I have seen so far under the current administration. So if you're in that dicey position where you don't have a valid visa stamp and you're out of your grace period, you definitely need to talk to an attorney about the logistics behind it, and your company needs to be prepared for those logistics.
Okay. And to the same question, uh,
Mhm.
when do you recommend somebody file change of status to H4? Let's say they are on the grace period. Is there a tactic that you recommend? This is the deadline by which you have to submit the form.
I will tell you that I never want to leave it to the last minute. Like, you don't want to leave it to the last day, right? But I would say 1 to 2 weeks before the end of your H4 would be good. Maybe 2 weeks to just make sure it gets receipted in. You can file 539s online, which is really good because you get an instantaneous receipt notice in that scenario. But the reason why I wouldn't file it a lot earlier is just in case you do get a job, it is just easier and you don't have to spend the money to withdraw the case and you already paid for the H4, right? And we can just directly file the change of status or change of employer to H1B.
Okay, fantastic. All right.
Mhm. So for path two, H1B to B1B2 to H1B, some of the things that I actually said in path one will apply to this. The difference though with B1, B2 is you have to be very careful with it. Why? Because you need to be able to explain why you need a B1, B2, right? So I haven't had a lot of pushback for people who ask for the first request, right, to change status to B1, B2. It's that if you start extending that B1, B2 request for more than 6 months, you file another one is where things get really, really crazy. But kind of same rules apply. If you file a change of status to B1, B2, and then you finally get the job on the H1B later on, but you're outside of the 60-day grace period, um, that's where we have to think about valid visa stamp, yes or no, right? If the answer is no, logistics, right? Faster for you to get into starting this job if you were to leave the country and go consular process, depending on what consulate that you're going to be going to. But with B1, B2, personally, I feel like it's the weaker category. I personally prefer if you have H4 as an option to go down that route. Because again, with B1, B2, it's still an argument. You need to show non-immigrant intent, right? It's not a dual intent provision. You need to show that you have an intention to leave the country at the end of your stay. You need to have a reason. Are you staying here as a business visitor? Are you investigating new investments and the like, or visiting exhibitions and conferences? Or for B2, are you visiting family and friends? Or sometimes I've seen this happen, which is that I've been working really, really hard. I need to take a sabbatical. I want to travel the United States, etc. Those are grounded reasons for the B1, B2. But remember, it's still an argument. Am I a business visitor? Am I here for tourism?
Okay. What if somebody had an I-140 approved and they got laid off, and then going to B1, B2? Would that be an option, or probably that's going to be a getting an RFE in terms of you have a pending immigrant petition?
So this is also tricky because I've seen both happen, right? So what do I mean by seeing both happen? The I-140 itself, historically, right, as a review, doesn't necessarily show immediate intent, right? The previous administration under Biden seems to have taken intention coming from when you file the 485. Just because you've proven your eligibility doesn't mean you actually want to have a green card, because you have to do this second step, which is the 485, or if you're abroad, the consular process. However, under this administration, we have seen those questions come up. Some people who have approved I-140s who are on single intent visas, let's say you're traveling, you have a valid F1, right? That's where things come up, which is I see this approved I-140. Are you actually going to be returning to your home country at the end of this F1? I do think it's a higher risk. But one thing that I will say is that if you have a meritorious, non-frivolous application and you file an H1B change of status to B1, B2, while it is pending, you are allowed to stay in the United States, and generally you do not accrue unlawful presence during that time, even if you withdraw the application and you leave the country. Leaving the country automatically abandons it. So if you need to buy time and you have no other options, the B1, B2 can still be a relevant way to just buy that time. But I will tell you, Raghu, and for any one of you who, if you do have an approved I-140 and you have this situation, you really need to talk to an attorney to balance out the pros and the cons of either choosing to leave the country and applying for jobs and then coming back on a future H1B versus trying to take the risk of the B1, B2. Because I think this administration is really evolving. That, what I had just said, that pending authorized stay can change at any time, right? That treatment, those tolling provisions, we call it, can change at any time.
Okay. All right.
Mhm. So when it comes to path number three, H1B to F1 day one CPT, it's not a bad idea. Think about the I-140 rules that I talked about earlier when you have an approved I-140. However, with day one CPT, I have one big thing. Unlike a lot of practitioners, I feel like I'm not necessarily a proponent. I'm more of an ambivalent practitioner because some people will say it's a big red flag, right? Day one CPT fraught with a lot of issues. The main issue that is sprung up from day one CPT is maintenance of status. Did you actually go to school? Did you actually like, you know, go in with an academic intent or are you just there working? The government is very well aware you went to day one CPT for CPT. So what they're trying to do is check, did you go to classes? Did you do your homework? Did you actually go to class, period, right? So because of that, if you are interested in day one CPT, you can still, I wouldn't say avoid the red flags, but you can be prepared for those questions in the future by keeping your own records and evidence that you actually did those classes. A lot of the universities that do day one CPT, they'll say, oh, we keep the attendance records. We have a professional package that gets put together when these RFEs for maintenance of status come. Don't rely on that. The onus and the responsibility is on you. If you're driving to school and you have a toll booth or everything, keep that receipt, right? If you're going to class and you wanted to buy Starbucks at the campus, keep that receipt. If you bought books, keep that receipt as well. And alternatively, or another thing that you can do is that keep copies of your syllabi and the homework that you did for that class or those tests that you did, because that's the biggest question is maintenance of status that gets raised on day one CPT.
Okay, all right.
Okay. So we can do questions now if
Uh,
you want.
and the audience who are here in Zoom, you can go to the Q&A option and type in your questions. We already have a few questions in the queue that we'll go through. And for those who are listening live on the Facebook platform, on the commenting section, please post the question. I'm monitoring one group, and if you're posting questions on your F1 visa Facebook group, I'll be able to ask those questions to Nicole. All right, so let's go with the first question from Nicole. Do you want to do the disclaimer
Yep,
slide?
I'll do the disclaimer. So I don't have it on Slack, but I'll say it out loud, right? So always remember that me answering these questions does not establish an attorney-client relationship between myself and you. I cannot give specific legal advice, and it should not be treated as specific legal advice. I will give answers in generalities because I do need to know more about your case to actually give you a specific answer. So for those of you who are asking questions here, I will give you general answers, let's call it, that are general overviews. But if you really want to know the true answer to your particular question, a consultation is really very much needed. Another thing is remember that this is a Q&A. It's open and public. So people are going to be hearing about what you're saying and what you're asking. So anything that's confidential, anything that is private, do not share it on this platform. Please schedule a consultation. Our firm does offer for qualified individuals free consultations. We do try to keep it very, very easy for people to get in touch with us. So please don't hesitate to reach out to us if you prefer that private setting. Okay?
Okay, all right, sounds good. So
Okay.
let's go to the first question. Can you clarify the H1B concurrent option? Let's say I'm on STEM OPT. What I need to do is find an university or an NGO that is part-time role and full-time role in a private company and no need for H1B sponsorship. Is that right?
So it's not an NGO. Not all non-government organizations qualify. It's universities, colleges, and non-profit research organizations. What I mean by non-profit research organizations is that you can prove that the organization is devoted to research, basic or applied research. There are other categories. They call it affiliations, right? So if it's affiliated with a university or college, a nonprofit, that can count. But what you're saying for NGO does not count in that context. However, just to answer the question, that is accurate. If you have a part-time role and they sponsor you for a cap exempt H1B and that gets approved, you can hook on a private employer through a concurrent application. Um, but this is a very nuanced way to do it, and I do not recommend filing these kinds of cases pro se, which is without an attorney, because you're using a lot of exceptions to the rules. I won't necessarily call them loopholes, it's just you need to really be fluent in the citations that allow you to do that.
Okay. Next question is I got laid off on H1B in June, but my I-140 approval for green card also came in the last week of June just before layoff. If I go back from USA, basically I leave USA, can I come back to the US with another new 6 years on H1B?
So this is actually a very complex question because this is one thing that you need to check for, right? So the I-140 approval, you you only get to keep it for yourself if they maintain it for at least 6 months, that approval. Now, I don't know what you mean by it came in June, right? I really would need to know more about that if possible. But let's assume for argument's sake, the I-140 approval belongs to you, right? Or what if it was a self-petition EB2 and IW? Who knows, right? If you have an approved I-140 and it belongs to you, you can leave the country, right? apply for roles, and then you can come back on a brand new 3-year extension thereafter. You don't have to stay and get a new job within that 60-day grace period or maintain your status in the United States waiting for that new job. You can just leave and come back later.
Okay. Another question from the same person. I have an I-140 approval. How does it help to come back after 60 days of grace period?
So I kind of touched upon this. Essentially, what I'm saying is that you are still entitled to those 3-year extensions or those 3 years of brand new employment time after that approval has been given to you for and it belongs to you, even after the 60-day grace period. So even after the 60-day grace period, you can essentially keep continuing on. You can come back with a brand new 3-year approval. You don't have to do it while you're on the 60 days.
Okay.
Your employer will file a new employer.
Okay.
Mhm.
Another question based on the day one CPT, H1B to day one CPT. Is it possible to come back from day one CPT to H1B?
Uh, it is possible, yeah, because you're allowed to change statuses back to your H1B. So if you're on your F1, let's say you're half a semester in, you can file to change your status back to H1B if you still have time entitled to you on your H1B. Remember, it's 6 years total, cumulative, 6 times 365 days in the United States on H1B status.
Okay. I knew this question was going to come, and there it is from Yash. Can I stay on 60-day grace period after H1B layoff? I heard people are getting NTA by default.
So I've seen this come about too. Raghu, you and I have definitely talked about this. Yes, there are people that have been getting this NTA, but the regulations are still pretty clear, right? Which is that you are entitled to this 60-day grace period. A lot of people have been able to close those NTAs once they've received it, because any reasonable person who reads the rules will say, well, you have the 60-day grace period, or whatever the I-94 is earlier. The reason why these NTAs are happening is I would like to think it's a database issue or maybe it's a new hidden policy, but we don't know just fully yet. But it's because the H1B, the one that you got approved for, got revoked. So in the system or the way they look at it, it's that now you no longer have this valid, let's call it I-94 or validity to stay here in the United States. So therefore you're out of status, but that is not the case, guys. People have been able to close these NTAs. It is unfortunate. I do not believe this is happening to the majority of individuals. It has not happened to a client of ours just yet, just to give you some insight into the scale at this moment.
Okay. And
Mhm.
question from another question. What happens if H1B 6 years is already used up? And if we leave the country and later if you apply for a job, will I get another new 6 year period and come back?
You will need to re-enroll in the lottery. It's not about like leaving for just 1 year and you get more. You've already exhausted the 6 years that have been entitled to you for that kind of lottery, let's call it selection or that cap. So you would need to enroll again. Now, I want people to remember it's 6 times 365 days in the US. There's something known as recapture, which is if you leave the country or you're traveling when you're on your H1B, those days, those 24-hour periods that you're outside of the United States, you're entitled to get that back.
Okay. So another question from about H1B layoff. I think I'm going to rephrase that question. Probably that will be a good option. If somebody gets laid off and they are on a 60-day grace period, if the employer withdraws the H1B or they notify USCIS, this person is no longer employed with us. Does that H1B still belong to that person and they do a transfer to a new employer?
Yes, because you've been previously counted against cap. That revocation is just in practice the way that you inform the government that you're no longer employed by the company and that they're no longer, I won't say it's like the obligation to you, it's just that this is no longer them sponsoring you, right? You still have been counted against gap. That approval notice just proves that you have it.
Okay. So
Mhm.
another scenario, let's say an employer A's petition is approved for 3 years and the person gets laid off. In the 60-day grace period, this person gets another job, transfers the H1B, and goes to another employer. That H1B is still valid, right?
Yeah.
Previous approval. Can this person just decide to come back later if they got rehired, or they
Yeah,
still?
I think I can give you a good example that's easier to like illustrate, right? Let's say you graduated from your bachelor's degree. you decided to work for McKinsey as a consultant, right? You won the H-1B lottery, they approved your H-1B, and you worked 2 years as a consultant. And you know how these consultancy programs like cover MBAs, right? They're like, congratulations, we're going to cover your MBA, but the MBA is in Oxford, in London. And you're like, okay, so I'm going to move from the US to London. So you leave the United States, you kind of temporarily leave that job. You go to London, you spend 2 to 3 years getting your MBA. So how does McKinsey bring you back, or how does any company bring you back after you graduate from that MBA program? Well, they resuscitate your H-1B because you've only used 2 years out of the 6 years that you were entitled to. So even though 3 years have passed, or 2 or 3 years have passed because you're in this MBA program abroad, you can still come back to the United States by using the remaining 4 years that you're given as part of that cap selection. Of course, they need to file for a new H-1B, but you don't need to do the lottery. They basically say, hey, we need a new 3 year approval. Here's the proof that they were previously approved for an H-1B and that they were selected through that lottery process.
Okay. All right. Uh, Another question. I got laid off on 15th August. I have a valid H1B stamp until August 26 next year and have an approved I-140. If I switch to H4 and come back to H1 after my grace period, but before my visa stamp expires, can I withdraw the H1B petition then, or is that not recommended?
So I'm assuming that when you mean come back to H-1B, that you're going to get approved after your grace period on the H-1B has ended,
Yep.
quote unquote. Um, in terms of calculating when to withdraw the H4, I traditionally tell people to withdraw it once they've gotten the receipt notice for that H1B, and they're out of the country, right? But it's much more complicated. So Raghu, where this becomes complicated is I need to really understand their statuses, right? How much time do they have left to stay? But the withdrawal for the H4 can also be automatic in the sense that when you leave the country, you automatically abandon a change of status application. You can't stay in the United States. So if you're telling me you're going to leave in about a month's time, then I would withdraw it when you were leaving.
Okay.
Mhm.
Uh, a person is asking, can you explain a bit more about concurrent H1B versus cap exempt part-time H1B? If someone is on STEM OPT and the next year is the last chance for H1B lottery, how can this part-time cap exempt H1B work?
So if you don't win and you find out by April 1st, right, the first week of April that you didn't win, assuming that you still have time left on your STEM OPT thereafter, which usually you do, you got to start finding that cap exempt job. It can work. You have to just find the job because the H-1B cap exempt doesn't rely on the lottery cycle where you have to wait until March and then April. Universities and colleges and the companies that qualify for cap exempt can immediately file for the H-1B. They just have to do the process of acquiring that H-1B. They just don't need to prove that they've won the lottery.
Okay, another interesting question. I got laid off while STEM OPT application is pending. My initial OPT ended on June 5th. What should be my next steps in order to maintain my F1 status? Will this termination affect USCIS decision on the pending STEM OPT application?
Ah, you got terminated when your STEM OPT was pending. My initial OPT ended on June 5th. Sorry, I'm just trying to look at the details. What should my next steps be to take in order to maintain my F1 status? Will the termination affect the USCIS decision? So USCIS won't immediately know that you're no longer working for the company. This is actually a question better suited for a DSO than me. So even though I've dealt with the inner workings, this is one of those scenarios where you have to inform the person who issued the I-20 because the STEM OPT recommendation was provided and you need to find a new employer to provide it, a new STEM OPT recommendation. Hmm, tricky. Personally, I will tell you that this is where consultation is needed because I will be honest with everybody, I have to do research on it. I have to see how they treat it during a pending application. I would encourage all of you, right? If you are in this situation, that you must talk with a lawyer who will do the research for it and also see what your DSO materials have. A lot of students are given a binder, right? When they graduate or approaching graduation, when it comes to maintaining their statuses. And on STEM OPT requests, that's usually one of them. But my understanding is that you should be able to use the unemployment periods allocated because at the time of filing, the job was true. But this is also a good PSA, let's call it, Where premium processing for those EADs is available, it is always a good idea to premium process and do not wait for those EAD cards. I would rather you have it so that you can immediately feel that stability of, oh, I have unemployment period. It's okay. I'm not immediately screwed. Here, it's actually very challenging because the STEM OPT recommendation was based upon that rule.
Okay, all right. Um,
Mhm.
Another interesting question. I'm on STEM OPT. I have an approved H1B on third attempt, I-797 from an employer in the last month. Now I got laid off before H1B could be activated. I'm planning for day one CPT, but if I find an employer on day one CPT, can the cap selected H1B be used without lottery again?
Mm. So this is a legal gray area, guys. The
Legal,
government
yeah.
is not. Yeah, so but I want to touch upon this for everybody here, right? Because I think I can show you at least the spectrums of that gray, right? The conservative opinion is that you need to have activated that H1B by working for them on October 1st onwards before you can use it for other things, right? But there has been successful legal arguments, especially if you have been approved for a change of status to H1B through the CAP process rather than a consular approved one. However, that's more of what I call a more liberal interpretation of things. So in this situation, Tuja, it's really important you talk to a lawyer, right? And we need to know all the details. We need to know how your employer filed the application, and you go from there.
Same scenario, Nicole. Let's say the person gets laid off September 15th. The H1B
Hmm.
is supposed to be starting on October 1st.
Yep.
You don't have a job on October 1st. Does that mean the 60-day grace period will start on October 1st?
Well, you're not on H1B yet, even if you got the approved, because the scenario that you're telling me is that it's September 15th, right?
Mhm.
And you said that that person is on F1 and they got the approval for the change of status to H1B, but that change of status doesn't activate until October 1st. Because if you look at the approval notice, it's October 1st onwards,
So
right?
if they don't have a job on October 1st, does it mean that they automatically are on H1B, but day one of 60-day grace period will start? Or no?
No, that's not what happens because you have to still maintain your underlying F1 if your OPT is still available,
Mhm.
right? Let's say you got this change of status approved, but your underlying F1 OPT was still another year left, or let's say it's STEM OPT, you had another like 2 years left, then essentially that change of status to H1B to me is not effectuated, right? Or not immediately effectuated because the employer is going to revoke it. The employer should be revoking that change of status. So you need to maintain your F1 and then figure out if you are available to change status back into your H1B to by a different employer, or if you need to hold on to that OPT tightly and find another alternative pathway.
Okay.
Um, Trickiness.
To bunch of questions. To convert, how are we on time? So we are coming up on 3 hour mark, 3 o'clock mark.
Yeah, and I do have a hard stop unfortunately today, so
Okay,
I think this
so
could be our last question.
sure, let's just do one question. Let me see which is the shortest one in the list. To convert from H1B to B1, B2, how much fund is sufficient to show for 6 month stay? How do we show it? The sudden deposit from a friends or family create a red flag.
Okay. Oh, how much funds is sufficient to show for a 6 month stay? It's actually a very wide question because it depends on what you're telling the government you're doing for that B1, B2, right? If you're telling the government that you're going to Disneyland, that's not a cheap visit. They're going to want to know like how much money you have to do that. If you're telling the government that you're visiting some family and friends locally or in another state nearby, that may not necessarily need as much. There's no such thing as sufficiency because it does, to me, depend on what you're trying to prove, right? Geographically, it is cheaper to be in Alabama than it is to go to New York City. It's just that's how it works. How you show it is usually through a bank statement. But when it says sudden deposit from friends and family create a red flag, again, depends on the context, right? If you're young and your parents are still supporting you and they're sending you an allowance or they're sending you some help, I don't think it's that much of a red flag. But that being said, it's the more the merrier. Sudden deposits can scream out as if, what if you're gonna just transfer it back once you're once you're approved? So you should accumulate funds over time. Guys, start saving if you can. I know it's hard as a student, but when you have the money, try to put it away. It's always a good idea.
All right, fantastic. All right, I think we are at 3 o'clock. Folks,
Mhm.
thank you for joining. This is just the first webinar with Manifest Law and Nicole. we will be hosting few more webinars. I think the next one is going to be towards the last week of September. I will be posting an announcement about what topic we're going to cover on that webinar. Just like this, we will do a presentation and then also we'll have Q&A relevant to the topic. If you are looking to get help from Manifest Law and you want to talk with Nicole to discuss strategies, I have posted the link on the chat. It's manifestlaw.com/happy schools. So if you go there, you'll be able to request a consultation. And I believe there is also a discount that you can get if you just mention Happy Schools in that request. All right. Thank you, Nicole, and looking forward for the next event.
For sure. Thank you everyone for having me here. Hopefully this has been helpful for everyone involved.
All right. Thank you, everyone. Bye bye. Take care, Nicole. Bye bye.